The marble walls of the Supreme Court chamber carried an air of tension as Congresswoman Jasmine Crockett stood before the 9 justices, her navy suit sharp against the polished mahogany podium. The keyed span cameras tightened their focus as Justice Clarence Thomas leaned forward, his expression stern and unyielding. What followed unsettled the entire legal community. "Congresswoman," Thomas said, his deep voice cutting across the chamber, "I've reviewed your brief multiple times, and frankly, your grasp of constitutional law appears basic at best. Perhaps a refresher on legal interpretation would be wise before presenting here." The chamber went still. Reporters froze over their keyboards, while the other justices shifted uncomfortably in their high-backed chairs. Crockett, however, did not falter. Her eyes narrowed slightly, and her grip on her notes tightened as she reached for a prepared folder. "Justice Thomas," she began firmly, "I appreciate your concern for my legal training. But in the next 5 minutes, I intend to show why your conclusion is not only incorrect, but also potentially misleading to the American public." No one could have anticipated what came next. The folder she opened contained research that would not only defend her qualifications, but also turn Thomas's judicial record against him, leaving the senior justice, for perhaps the first time in his long tenure, at a loss for words. Before we examine this remarkable exchange further, take a moment to like this video and subscribe to our channel for more in-depth political analysis. Don't forget to turn on the notification bell to stay updated on the biggest moments shaping American politics. Justice Thomas sat in his familiar seat on the right side of the bench. His presence reflected more than 3 decades on the court. At 75, he had become increasingly outspoken, far removed from the justice who once went years without asking questions in oral arguments. Now he stood as a central conservative figure, unafraid to challenge those who opposed his originalist interpretation of the Constitution. The Constitution means what it meant when written, he had declared recently, not what modern lawyers want it to mean today. For Thomas, this case went beyond legal technicalities. It touched the foundation of the principles he had spent his career defending. The matter at hand, Richardson v. Election Commission of Georgia, involved new voter ID laws that could restrict access for hundreds of thousands of voters, particularly in minority communities. Conservative justices, led by Thomas, seemed inclined to view the restrictions as necessary safeguards. Liberal justices considered them tools of voter suppression. Facing them stood Congresswoman Jasmine Crockett, a 42-year-old former civil rights attorney from Dallas. Only in her second year in Congress, she had already emerged as a prominent Democratic voice. Her background included defending protesters, challenging voter suppression, and litigating civil rights cases across Texas. She had built a reputation for presenting complex legal issues in plain terms. Invited to speak because of her expertise on voting rights, Crockett understood the stakes clearly. She was not just representing her district, but millions of voters whose access to the ballot could be limited. "This isn't theoretical for me," she told her staff in preparation. "I've watched polling places close, voters turned away, and voices silenced. Justice Thomas may debate theory, but I've seen the consequences firsthand." The tension in the courtroom was evident long before the exchange. Observers speculated the justices were headed for a 5-4 split, with Thomas likely writing the majority opinion. His pointed remark toward Crockett was more than a personal critique. It was an attempt to discredit her credibility before she had even presented, but Crockett had anticipated this approach. Her team had studied Thomas's increasingly confrontational style and prepared accordingly. In her folder lay material designed to shift the entire argument. The chamber grew still as Crockett composed herself. Justice Elena Kagan raised an eyebrow toward Thomas. Justice Ketanji Brown Jackson straightened slightly in her seat. Everyone sensed a turning point. "Justice Thomas," Crockett said, her voice strengthening. "Let me respond to your concern by addressing the constitutional issues directly at stake here." Thomas leaned back with a faint smile. "Proceed, Congresswoman. Enlighten us." His tone carried clear condescension. Noted by several journalists in the press area, the 14th Amendment's Equal Protection Clause and the 15th Amendment's guarantee of voting rights regardless of race form the basis of my argument. Crockett explained steadily. Georgia's law creates barriers that disproportionately affect specific communities, as the data in my brief shows. Thomas cut in quickly. "Congresswoman, the amendments guarantee equality under law, not convenience. The statute applies to every voter equally." Several conservative justices nodded. Justice Samuel Alito pressed further. "Where exactly in the Constitution do you find a right to vote without identification?" The questioning came fast, but Crockett stood firm. "Respectfully, Justice Alito, the Constitution ensures that laws, though neutral on their face, must not create discriminatory results. The data clearly demonstrates." "Data can be manipulated," Thomas interjected sharply. "What cannot be altered is the text of the Constitution. It does not specify procedures for verifying voters. That's the basic distinction you seem to be missing." Murmurs rose in the gallery. Thomas's remarks directly challenged not only Crockett's argument but her integrity. Chief Justice John Roberts shifted uncomfortably, sensing the tone had become personal. Crockett breathed deeply. Her assistant slid another document toward her, Independent Analyses, confirming the disproportionate effect of the Georgia law. Still, she knew data alone wouldn't shift the tone. Justice Sonia Sotomayor attempted to redirect. "Perhaps we should look at the evidence in rural Georgia counties." Thomas interrupted again, eyes fixed on Crockett. "Before discussing county data, we must clarify constitutional principles. The Congresswoman seems to promote results-driven jurisprudence rather than textual fidelity." The session had turned into more than oral argument. Some observers later noted Thomas seemed intent on undermining Crockett personally rather than merely debating her claims. Time was running. Crockett looked at the clock, then returned her gaze to Thomas. Calmly, she began, "Justice Thomas, since you've questioned my understanding of constitutional law, I believe it's appropriate to review how these principles have been applied by this court, including by you." From her folder, she pulled a document her team had prepared, a detailed analysis of Thomas's opinions on voting rights cases over 3 decades. "In reviewing your record since 1991, she said, "we identified patterns worth considering today. For example, in Shelby County v. Holder, you argued Section 5 of the Voting Rights Act was unconstitutional from the start, not only in its current use." Thomas's jaw tightened slightly. Crockett pressed forward. "I have data here that shows how your reasoning in that case contrasts with later positions you've taken." The room was silent. Even court reporters seemed to pause. "Congresswoman," Chief Justice Roberts interjected. Glancing at the clock, "You have 10 minutes remaining." "Thank you, Mr. Chief Justice," Crockett replied. "That will be sufficient to demonstrate not only that Justice Thomas's critique of my understanding is unfounded, but that his own judicial record shows troubling inconsistencies." Thomas leaned forward, fingers interlaced tightly. The focus had shifted. Crockett was no longer only defending her argument, she was questioning Thomas's consistency across decades of rulings. Straightening her shoulders, Crockett continued with confidence. "Justice Thomas, you've suggested my understanding is elementary. Allow me to respond by examining your own application of constitutional principles in voting rights matters." She placed a timeline of his past opinions on the podium. "This analysis reveals contradictions that are difficult to reconcile with the originalist approach you claim to follow. Thomas's face remained controlled, though his fingers tapped lightly on the bench, an unusual sign of tension. In Crawford v. Marion County, in 2008, you supported Indiana's voter ID law, citing state interest in election integrity despite limited evidence of fraud. Yet in Arizona v. Intertribal Council in 2013, you argued state sovereignty should override federal regulation, reversing your earlier stance on federal versus state authority. And most telling, she continued, her voice firm, in Shelby County, you dismissed current data and argued the Voting Rights Act's preclearance was unconstitutional because it relied on outdated history. Yet just last term in Allen v. Milligan, you dismissed current evidence of discrimination as well, concluding that the act could not address racial gerrymandering at all. In effect, neither history nor current data mattered, contradicting your own reasoning. The chamber was silent once again. Crockett had shifted the debate entirely, turning Thomas's challenge back onto his own judicial record. A quiet ripple moved across the courtroom. Justice Kagan leaned forward with interest, while Justice Kavanaugh glanced toward Thomas. These contradictions highlight something important, Congresswoman Crockett said, her voice gaining strength. The inconsistency isn't in the Constitution itself, which hasn't changed. It lies in how principles are selectively applied depending on the outcome being sought. Justice Thomas's expression grew stern as he leaned toward his microphone. But Chief Justice Roberts raised a hand, an unspoken reminder about interruptions during timed arguments. I did not come here simply to criticize, Crockett continued. I came to defend voting rights. Let me tie this directly to today's case. She lifted a blue folder. Inside are sworn affidavits from 173 Georgia voters who were wrongfully prevented from casting ballots, despite being fully eligible. She pointed to one specific case. Among them is Mrs. Dorothy Wilson, 86 years old. She has voted in every election since 1956. But was turned away because her married name on her ID didn't match the maiden name listed on outdated voter rolls. Crockett displayed a photo of the photo. Elderly woman holding both her voter registration card and driver's license. Mrs. Wilson was born during Jim Crow. She marched with Dr. King, and in 2024, she was denied the right to vote due to a clerical mismatch. For the first time, Thomas's expression softened slightly. The Constitution's meaning does not shift, Justice Thomas. On that, we agree, Crockett continued. The 15th Amendment clearly prohibits denying the right to vote based on race. When laws result in voters like Mrs. Wilson, primarily from minority communities, being blocked from the ballot box, while others face no such obstacles, that violates the very protections the amendment was designed to secure. Turning to address the bench as a whole, she added, my understanding of constitutional law isn't shallow, it is grounded in its application to real citizens. The Constitution wasn't written as an abstract exercise. It was written to safeguard people like Mrs. Wilson. Placing the affidavit on the podium, she concluded, with respect, Justice Thomas, what is truly elementary is insisting that so-called neutral laws with proven discriminatory effects somehow align with the Constitution's text and purpose. The chamber was silent. Justices scribbled notes quickly. Justice Jackson allowed herself a faint smile. Justice Alito shifted uncomfortably. Thomas leaned forward again, his earlier dismissiveness replaced with careful attention. Congresswoman, he said in a notably different tone, you suggest I've been inconsistent. Couldn't the same claim be made about your own legal positions over time? This time it was a genuine question, not an insult and acknowledgement of her standing as a legal equal. Crockett nodded. A fair question, Justice Thomas. Yes, My views have evolved as I've seen how these laws impact people directly. The difference is that I don't claim absolute originalist consistency as the foundation of my philosophy. I admit openly that witnessing someone like Mrs. Wilson turned away informs my interpretation of what the 15th Amendment protects. She gestured toward the affidavits. These are not theories. These are American citizens being denied their most basic right. If defending their access to the ballot is elementary, then perhaps this court needs more elementary thinking. Thomas sat back, unreadable, but his earlier tone of ridicule was gone. For perhaps the first time in his tenure, he appeared momentarily without reply. Your time has expired, Congresswoman Crockett. Thank you. Chief Justice Roberts announced as she gathered her documents. Justice Ketanji Brown Jackson gave a small nod in her direction, subtle but unmistakable. Even Justice Kavanaugh leaned over to whisper to Justice Barrett, both appearing thoughtful rather than dismissive. The attorney for Georgia approached the podium for rebuttal. But the atmosphere had changed completely. The certainty that had earlier radiated from the conservative justices now felt tempered by doubt. What began as an attempt to undermine Crockett's credibility had shifted dramatically. She had not only defended herself but had also turned the challenge back on Justice Thomas using his own judicial record as she returned to her seat. Reporters were already moving out of the courtroom to file their stories. Regardless of the ruling, this exchange had become the headline. Within minutes of adjournment, the first reports hit social media. A CNN correspondent posted, "Unprecedented. Representative Crockett challenges Justice Thomas," directly after he questioned her legal knowledge. Most direct confrontation I've seen in 2 decades covering the Supreme Court. By the time Crockett left the building, her phone was buzzing nonstop. Hashtags like #Crockett vs. Thomas and #Elementary Mr. Thomas were trending nationwide. News outlets dropped scheduled programming to cover what commentators were calling a historic moment at the nation's highest court. On the marble steps outside, reporters swarmed. "Congresswoman, were you prepared for Justice Thomas to challenge your legal credentials?" One shouted. "I came prepared to defend voting rights, not my resume," Crockett replied. "But yes, my team anticipated tough questions, and we prepared accordingly." Another asked, "Do you think this exchange will affect the court's final decision?" "That's not for me to predict," Crockett answered evenly. "Justices rule on constitutional principles, not oral arguments. I simply presented the facts as I understand them." Still, her team recognized the significance of what had happened. Later that afternoon, her legal advisor shared, "A clerk told me Thomas was silent during the internal conference afterward. That never happens. He always leads on voting rights." By evening, video clips had gone viral. The moment Crockett revealed the timeline of Thomas's past opinions had already drawn millions of views. Law professors assigned the transcript to students, while legal scholars debated its meaning across the spectrum. Harvard's Lawrence Tribe wrote, "Regardless of one's position, Crockett delivered a masterful argument. Using a justice's own words to test their consistency is advocacy at its highest level." Even conservative commentator Jonathan Turley acknowledged, "I disagree with her conclusions." But her presentation exposes a pattern that originalists must grapple with honestly. Newsrooms scrambled to cover the story. Fox News featured conservative scholars, some defending Thomas, others conceding Crockett's argument had been effectively delivered. MSNBC analysts called her performance extraordinary, noting that few advocates ever confront justices so directly. The White House offered no direct comment, but insiders confirmed senior officials had reached out to Crockett's office privately to express support. By the next morning, front-page headlines across major papers highlighted the exchange. Donations to civil rights groups rose sharply. many citing Crockett's defense of disenfranchised voters. Meanwhile, interview requests and speaking invitations flooded in. Rumors suggested Democratic leadership was considering her for strategic roles. But the attention also brought scrutiny, with conservative outlets digging into her record and Capitol Police tightening security after threats appeared online. Weeks later, Crockett addressed law students at Howard University. That courtroom moment wasn't about me or Justice Thomas. It was about whether our system can look beyond theory to the real effects of laws on people. Mrs. Wilson doesn't care about legal doctrines. She cares about voting. When asked if her exchange might change Thomas's perspective, she replied, "I don't expect to shift his philosophy. But I do hope it forces the court to confront the gap between theory and reality." Inside the court, deliberations reflected this pressure. Initially, justices had split 5-4 along ideological lines, with Thomas slated to write the majority opinion upholding Georgia's ID law. But during drafting, Justices Barrett and Kavanaugh raised concerns about ignoring evidence of voter impact. 2 months later, the ruling surprised observers. In a 6-3 decision, the court struck down key provisions of Georgia's law while preserving others. Chief Justice Roberts authored the opinion. Joined by Thomas, the 3 liberal justices, Barrett and Kavanaugh. Remarkably, Thomas wrote a short concurrence acknowledging that while the Constitution's text is paramount, faithful application requires considering its real-world effects. Scholars immediately recognized the shift. Many linked it directly to Crockett's arguments. Months later, she launched a Voting Rights Institute dedicated to gathering and presenting evidence of voting access nationwide. Donations poured in. The first hire was a staffer to help voters like Mrs. Wilson navigate administrative hurdles. At the launch, Crockett said, "Some called it a victory when Justice Thomas joined that majority opinion. But the real victory belongs to Mrs. Wilson and others who can now vote without needless barriers. That's not a partisan win, it's an American one." As elections neared, registration drives surged, many citing the case as inspiration. And in a small Georgia church basement, Mrs. Wilson, now 87, proudly held her new voter ID card. "I've been voting since Eisenhower," she said. "And thanks to that case, I'll keep voting as long as I'm able." What began as an attempt to question a congresswoman's legal skill had become something far larger, a reminder that behind every legal principle are citizens whose rights must be protected. For Crockett, the outcome was never about winning against a justice. It was about ensuring the Constitution's promises remain real for every American. If you found this analysis helpful, remember to like and subscribe for more insights into the moments shaping our democracy. Tap the notification bell for updates on voting rights cases nationwide and share your thoughts below on this historic exchange between Justice Thomas and Congresswoman Crockett.